then we begin. Plain.
What is it on behalf of people, Your Honor?
Anybody make a decision?
Yes.
Thank you.
Stephanie Canna on behalf of Mr. McLean. Please state your name for the record.
Matthew McLean.
If you must, yes. All right, record should reflect we've had a bench conference in this case. And go ahead.
It's fine. It's come to my attention that Mr. McLean has not been directly contacting the victim, but I have come by a few jail calls that concern me and what she's telling his family members, tell her that he loves her, as well as also mention to those specific family members who he's trying to get to be in contact with the victim, that if she does not show up, that the case would be dismissed, and suggesting things of that nature to them as well. So I have concerns, given that at first it's just to reach out with my love news, but then it's also suggesting outcomes that could interfere with this criminal case. So at this time, I'm going to be asking that the defendant be remanded, that text privileges in the jail where you want to give it.
And Your Honor, in response to that, there's been no evidence presented whatsoever that any information has been communicated to the complaining witness in this case. And just because he has knowledge of how things typically go in this matter and has expressed that knowledge is not indication that he has been trying to tamper with the case or the witness in any way, shape, or form. He's not in communication with her now. He's very concerned about her now. I told the court, and that's because there's been no communication whatsoever. She has been on repeat calling his family, and there'll be evidence of that if we do proceed further, trying to see what she can do to get the case dismissed. And that's evidence that we are going to be presenting to the court, and her taking culpability for the incident as it happened. I understand the prosecutor's position. And my client since then has not made any communication, reached out any way, shape, or form. Matter of fact, when he came in, because she has stopped communicating with her family and his family, he wanted to know if it was okay to call to get a welfare check on her because he knows her mental health status and her drinking status. Your Honor, my client has, as soon as he got out, he went and checked himself. He went into the Don Farms outpatient program.
I'm accepted for inpatient.
Into their inpatient program because he understands that a part of this incident stems from both of them and their sobriety and challenges with sobriety. So as soon as he got out, he came in and told me this is what he was doing, and I told him that's really good.
I have an official letter.
And so he is trying to fix this and straighten it out. He is aware that he cannot communicate with her directly or indirectly, Your Honor, and he will not be doing so.
Yeah, but they're repeated indirect calls. As I indicated to counsel, the concern sometimes when you get the I love yous, that can be concern. When you get wanting to check on somebody, can be a concern. I don't know that from the court's perspective that is such a concern, but when you start talking about how the case to these same third parties about that, basically if she doesn't show, then the case gets dismissed, and you're telling them in essence to communicate certain things to this person, that becomes a problem, and he shouldn't have been doing it in this case. Or certainly have made it clear he shouldn't have been communicating to third parties about her anyway. Some of it might be able to be excused, but I can't excuse that. So what I'm going to do is I'm going to adjourn the probable cause conference to...
Oh, Your Honor, we were asking for the exam to be set.
Okay, then it won't be addressed till the 21st, if that's what you want me to do. Otherwise, I'd give you a week, the 16th, your choice.
The 16th, Your Honor. We'll take the 16th, Your Honor.
I'll adjourn probable cause conference to July 16th, 2026, 9 a.m. At this point, given what the court has heard, defendant's bond is ordered revoked, defendant's remanded. Court calls case, people.
Miss Winter, when you arrive, please state your name for the record.
Leah Winter.
Thank you, Judge. She spoke with my intern at the jail the other day. My understanding is we're still working on trying to reach a resolution. If we can have a brief adjournment, we'll continue to get this matter resolved.
July 23rd, 2026, 9 a.m. Bond continued. Thank you.
I'll send Muhammad back to control. She wants me to ask for a bond, Judge.
Okay.
Would you mind if I do that? Thank you, Judge.
I don't think you want me to answer that, but go ahead.
Well, thank you for allowing me anyway.
Yeah.
In speaking to my client, it sounds like she has indicated that she will return to court should the court allow her an opportunity for a bond, not resources financially to be able to post the current bond. She's asking the court might consider a PR bond or a 10% bond, at which point I hope she could post that and she would return for all future court dates.
I've got nobody tomorrow. I was under the impression he gave me a PR already 2 weeks ago.
Judge Simpson did?
Yes. Then you
What?
She says she's under the impression you may have already given her a PR bond on this file 2 weeks ago. Is that what your file reflects?
okay.
You say a couple of weeks ago that I gave you a
For the last time I seen you told me to show up to court and you did offer me a personal recognizance. I got my host taken care of and I've been in custody ever.
Oh, slow down.
Sorry.
You're going too fast. Say it again.
I said, it's in the file.
Going too fast for him.
Sorry.
Go ahead.
I said that last time I seen you, you offered me a personal recognizance. I had my host be taken care of. They did. Nobody expects me in person tomorrow. And we've been under the impression that I had a PR.
She was moving too fast for me, Judge. What I think I heard her say is that 2 weeks ago, you told her that if she got all her holds in other counties cleared, then the court would entertain the possibility of a PR bond.
That sounds like something I would say. I don't.
That's all those holds are now cleared.
Currently.
Thank you.
But okay, so in the interim, she's gotten her holds cleared up.
Correct, Your Honor. She says she does have a court date tomorrow in Novi, and she is supposed to be there in person. So she requested the court allow her a release.
Got it. Do the people see that?
I'm double checking actually right now, Your Honor. I think part of the concern was there was a missed court date and defendant indicated she was in South Dakota at the time of one for BCC. So there was a bit of a concern about flight risk, but
She said she was in South Dakota to me.
Yes.
I would have remembered that.
Yes.
I think she said to Magic Hotel, Your Honor.
Oh.
Do you have an address to say with
I don't know why what was it? What's in South Dakota?
my mother? She just had surgery on this.
Oh, okay.
But I'm not leaving. I have a place to live in Adrian with my uncle, her youngest brother, Joseph Hunt.
I see 2 holds added to the next jail. One Novi and one MSP.
And
So I'm not, the MSP appears to be traffic and Novi looks like drug paraphernalia. I don't know if they would get her or not, but I still see 2 active holds. They may be cleared just with the next jail.
But right, correct. That's because she says she has a hearing in Novi. So it sounds like that one was cleared. They're
And then
gonna
it's
have
not coming
to
again.
walk in. Right.
That's correct, Judge. The Novi is cleared.
And then you got an MSP one that's probably, you think it's probably a traffic.
Yes, she says they've indicated they will not come get her.
Maybe
And
not.
there's a $1,000, 10% bond here on the misdemeanor case before Judge Washington. It looks like
turns to PR if I get a PR here. So
that's all I see next year.
She says Judge Washington has indicated that that bond will turn to a PR bond if she gets a PR bond here. So we just have to notify her that this court has allowed her.
It sounds like Judge Washington to leave it up to me.
Well, I don't know, Judge.
Just saying.
Maybe she deferred to you on this one. She wouldn't have any objection to a tether if necessary to help address the people's concern.
I'll read. What is Akin really saying now?
Doctors, you can pull up one of his notes on court index.
Oh, she knows how to do that? Okay, go ahead. What does it say? Did she put the notes in? Or
Note says Ashley motion. So.
it's from Ashley?
Yes.
Okay, go ahead.
This is client here, for pretrial custody, bond reduced to 1,010% to convert to PR if released out of this fine.
I have court August 3rd too.
Yeah.
And then by tomorrow.
During the agreement to see results.
So sorry, according to the law, did grant $25,000.
I think I did. I thought as we were talking that I already did, but
Perfect.
Yeah.
so
We don't need anything.
so Fisher has been they're wasting my time.
I took,
Yes, ICR, they never got it.
They're wasting my time, and then Akin really joined in, wasting my time. I could have been done with the whole docket by now. I thought I had given her that.
I owe you 5 minutes, Judge. I'm sorry.
Not a bad dispo.
I mean, I weeks of my time.
I know. It's all time I don't get back. All right. I don't know any
It was the 23rd.
23rd.
Yes. Thank you, Judge.
You're welcome.
So what do I tell ITR? Because I've been telling them.
What do I tell ITR? Have no clue.
Ms. Welding is gonna.
We will make sure.
Okay, thank God, because I missed my mom's surgery and
Okay, hold on.
okay.
We'll make sure that a proper dispo gets down indicating that your bond here is a PR. I think that the only thing that may need to follow is that Judge Washington's bond, that somebody
I'll reach out.
lets them know.
Yes, Judge.
Thank you.
You're welcome.
Yeah.
Okay.
All right.
Thank you.
No problem.
Okay, thank you.
Take care.
That's the most Feaster talked in like a long time.
I try to be quick.
No, you try to be quick. And then Akin really stepped in and we were going to be here all day. So, see, she doesn't know. She doesn't know where she's going. Excuse us. She doesn't know where she's going to go in line. Oh, because then we get she's hungry too. She's hungry too. And the mom's watching, so everybody will know. Huh? Oh.
This hearing illustrates an important rule that applies in many criminal cases. A defendant may be prohibited from contacting an alleged victim, not only directly, but also indirectly through other people. Courts take these restrictions seriously because even well-intentioned messages can be interpreted as attempts to influence a witness or interfere with the judicial process. In this case, the judge focused less on whether the defendant personally intended to intimidate anyone and more on the practical effect of the communications. Messages suggesting that the case would be dismissed if the victim failed to appear created legitimate concerns about the integrity of the proceedings. From the court's perspective, protecting the fairness of the case outweighed the defendant's interest in remaining free on bond. It's also worth noting that the defense presented evidence of the defendant's efforts to seek substance abuse treatment and comply with court orders. While those efforts may become relevant later, they did not eliminate the court's concerns about indirect communication. The key takeaway is that bond conditions are legal orders, not suggestions. When a court prohibits contact with an alleged victim, defendants should avoid both direct and indirect communication, unless specifically authorized by the court. Even conversations through friends or family can have serious legal consequences, including the revocation of bond.